their expectation was that this was going to be a breakaway, just like the other, 3 that he had up, or you know what I mean? So where are we then? My question is, under what circumstances would it be permissible for an object such as this mailbox to be created and maintained?
I don't think there would be any circumstances where that would be permissible if it's created in this non-breakaway fashion.
But there's no law against it. The post office has guidelines. They don't have mandates.
I understand that, but we're talking about common law duty of ordinary care. And again, we have to, if there is a duty of ordinary care, we have to consider if there is a public policy consideration sufficient to supersede that duty.
So are you telling me then a homeowner cannot reinforce their mailbox if they are the victim of repeated vandalism?
Yes, I am. That's what I'm saying. Because
Ms. St. John, if this mailbox were not located in the right of way, because there's 20 feet of roadway, 20 feet on each side, but sometimes in the country, their mailboxes, if it's an older person, the delivery person will still deliver to the mail closer to the house. If this was closer to the house and out of the right of way, we wouldn't even be talking about this, would we?
Correct. I mean, this mailbox is so close to the edge of the roadway that if you look at the photographs in the record, I'm holding up SUP 153, which is one of the police photos. You can't even see where the road ends and the edge of the road begins. That's the mailbox post that's still standing.
I'm trying to understand a little bit exactly what kind of rule you want us to write, because are you saying that anytime anyone has a reinforced mailbox that exceeds postal guidelines, that it's foreseeable, and that therefore there is a duty there? Is that the rule, or are we supposed to take these on a case by case basis and say, okay, well, how far is it from the road in this case? How well traveled is this road? Is it have there been accidents there in the past? Is it a bright line rule, or is it kind of a case by case?
I think you can't have a bright line rule in this situation. I think that the way the common law develops is a case by case basis, but that this court's decision with respect to outcomes under particular facts and circumstances guide future courts in analyzing future situations.
Counsel, does the rule even have to be made? Aren't you saying that under the facts of this particular case, where allegedly the property owner had actual and constructive notice as to the reasons why a mailbox is supposed to be able to break away, that it's an issue of fact that shouldn't be decided on summary judgment, but that reasonable minds could differ as to whether a duty existed here? Is that what you're saying?
Yes, Your Honor. Yeah, reasonable minds could differ as to whether a duty was breached.
So no rule has to be made that encompasses all situations. It's just, was summary judgment appropriate in this case?
That's absolutely what I'm saying, Your Honor. And returning to Justice Bruner's question before, I'm not sure I fully answered it. I mean, one thing that the Section 368 of the Restatement Section 2nd is very useful for is to talk about the duty is dependent on foreseeability, and to the extent you have a mailbox that is affixed to the home of the property owner and is 15, 20 feet back from the roadway, that's a different situation. So just as Justice Donnelly said, we have to look at particular circumstances. And again, our proposition of law number 1 was intentionally drafted to be narrow so that it takes into account these facts and circumstances, and the questions then go to a jury. The third point that I want to make before my time is up is that we're in an era of comparative fault to the extent that the lower courts felt that the negligence of a motorist eradicates any potential duty. That is absolutely inconsistent with comparative fault, which has been the law of Ohio for the past 41 years. And to base the duty on whether or not the motorist is operating with reasonable care simply jettisons us back into a period prior to 1980 where contrib completely barred a plaintiff from recovery. So with that said, I have no idea if I have any time left. But I will.
You have 4 seconds, but.
Thank you, Your Honor.
Okay, Mr. Leake.
Chief Justice O'Connor, and may it please the court, my name is Doug Leake, and I'm here on behalf of the defendants appellees Matthew and Diane Burr. And on behalf of the defendants, we ask that this court affirm the summary judgment that was upheld by the 6th District Court of Appeals in a well-reasoned decision on the basis that there is no duty with respect to off-road hazards that do not interfere with the ordinary and usual course of travel.
Counsel, could your clients have, who are fed up, understandably, with people vandalizing their property and trespassing on it, could they have put metal spikes in around the area of where the mailbox was, designed to puncture the wheels of any car that came over that curb?
Well, that goes to our point that any objects that pose a potential obstruction or hazard that is on the right of way that does not interfere with the usual and ordinary course of travel, there is no duty there. That's why this court's longstanding precedents have limited the duty to obstructions, hazards, objects that interfere with the usual and ordinary course of travel, just like this court addressed in the Swaysgood versus Pooter case. And that was a case in which there was a pole that was constructed that interfered with the usual and ordinary course of travel with respect to trucks making turns, that it was too close to the turning area, that it was inevitable that a truck in the usual and ordinary course of travel would strike it and cause an accident. This court has never extended that duty to off-road obstructions or hazards, or to motorists that veer off of the safe way of the roadway to the right-of-way. So it has.
So you believe that your clients could have done that if they so desired, put metal spikes designed to puncture the tires of any wheel that came off the road, as long as it didn't interfere with the ongoing traffic?
Yes, I'm not here to condone what they, if metal spikes or something like that is the proper way to do it. But I'm wondering
where the line is. Where's the line?
The line is that object or hazard cannot interfere with the usual course and ordinary course of travel, and that there is no duty for a motorist that veers off the road. The key here is that the public has an absolute right to travel on the roadways in a usual and ordinary manner. The moment that motorist veers off of that course of the safety of the travel, that same protection does not extend beyond that roadway to the right-of-way and objects. And a key to this case, and the exception that the plaintiffs are asking this court to carve off judicially, could potentially involve any objects that are on the right-of-way. And that this court in Turner was concerned with that, noting at paragraph 23 that practically every item in a right-of-way could potentially impose liability. And as examples here, if this court accepts plaintiff's position here, any roadway obstruction or hazard, like decorative boulders or rocks, signs, a vegetable stand in the country, or cars parked for the purpose of selling a car. Obviously, that car is parked there consciously. Also, it is indisputable that that car in the right-of-way parked there would be an obstruction. It's 2 tons and would be a hazard.
But Mr. Leak, it has to be willful, wanton, or reckless. You're just almost saying that we would find some kind of strict liability. This was an intentional act, and there's got to be some element of proof that placing it there was willful, wanton, or reckless. Do you agree?
Well, the decision of the court came down to the duty. That's what we're here for, and that's what the proposition of law is. So what we focus on here for the purpose of this case and what the plaintiffs are asking an exception to is duty.
But isn't duty also determined by foreseeability?
Yes, and in terms of foreseeability, this court in Turner at paragraph 23 has already addressed the specific issue where it held that there is no duty imposed where the danger to vehicles that may foreseeably leave the travel portion of the roadway. So in paragraph 23 of this court's decision in citing the Ramby versus Ping case, this court already acknowledged that it is foreseeable for cars to leave the roadway. So that this issue of foreseeability has been addressed by the court. Also, foreseeability has never been the linchpin of establishing duty. In other words, foreseeability does not equate to duty. There are other aspects of duty. There's a whole host of criteria of considerations, this court's precedent, policy, and other factors.
Sure, but you can't have duty without foreseeability. I'm not saying foreseeability is like part and parcel, but it's an element.
No, exactly. Foreseeability is just one factor. I'm not eliminating foreseeability altogether. It does not equate to duty. It is not the linchpin. And as this court acknowledged in the Turner case of paragraph 23, that it did take into consideration the foreseeability of cars coming off a roadway. And still, in the Turner case, it upheld that statement of law that the duty is only imposed when an object interferes with the usual and ordinary course of travel.
Is foreseeability a complete question of law? Can it ever be a question of fact? Is it mixed, or is it always a question of law?
I think it's a factor to be taken into consideration. So it's not a matter of law. But in a case like this, it is foreseeable for cars to leave a roadway. Obviously, in retrospect, it's foreseeable. But once again, foreseeability, the other factors is you take into consideration is where is it foreseeable? Time, location, condition. There are several factors of foreseeability. That's why it's not the linchpin of establishing duty. And the plaintiffs highly rely upon foreseeability for this court to carve out an exception here. And with regard to them, they are requesting an exception. And I do want to make 4 points on this in terms of no exception for the conduct that they are talking about here is the conscious, the conscious effort to put this mailbox in its condition, even though it's stipulated or it is undisputed that it did not interfere with the roadway. The 4 points I'd like to make is that this court has already addressed this issue of hazards in the right-of-way and have not carved out that exception.
But just one other thing. So what way, well, how do we analyze the postal regulations? I mean, it was not only not the right size post, and it was not only buried too deeply, but it was too close to the road, according to the postal regulations. How does that play into this?
Well, first of all, guidelines do not set forth a duty of care. They are just guidelines, okay? And in this situation, this court has routinely deferred to the legislature in terms of regulation of roadways, whether it be utility poles, traffic lights, traffic signs. This court can also defer to the legislator with respect to the Postal Service in terms of mandates or statutory requirements, Ohio Administrative Code, the revised code. The legislature can enact such things like that in order to make it a mandate, but there is no law and no mandate.
But wouldn't those postal guidelines be relevant evidence for a jury to consider?
Well, in terms of, I think the scenario where it would be an issue for the jury is if the mailbox interfered with the usual and ordinary course of travel. That's where it becomes relevant. But what's interesting here also is the guidelines that the plaintiffs would want this court to say that should be followed. What is overlooked is those guidelines, those kind of mailboxes still pose an obstruction and a hazard to motorcyclists and cyclists. Obviously, it would still constitute under those guidelines a obstruction or a hazard for those individuals. So the key here is that the guidelines.
So counsel, I'm sorry, what are you saying, that a mailbox situated where it was is in the right of way poses a foreseeable danger to bicyclists?
Oh, I'm saying hypothetically, if the guidelines that the plaintiff suggests should have been followed were followed, that mailbox would still pose an obstruction and hazard, and for motorcyclists or cyclists that veer off. So regardless of the guidelines, any mailbox, any kind of object that I've already mentioned, for instance, parking cars at a graduation party or a barbecue, that's a conscious effort to place a car 2 tons in the right of way, knowing that if anyone veers off and runs into it, it's going to be a hazard.
Counsel, what's the purpose of the right of way?
The right of way is an easement where the government can regulate it and also allow the abutting landowner to use. And so the key also is that, that the government can regulate those right of ways and has done so with regard to utility poles, traffic signs, guardrails, but has chosen not to regulate that specifically with regard to mailboxes. And there's just guidelines. And so that's the purpose, is that it is provided, for the government to regulate. And utility poles, for example, they can't be there, correct? Utility poles, that's what the whole slew of cases are dealing with, are off-road utility poles, the Turner case.
Right.
Those are our cases. And this court has already addressed, obviously those utility poles are consciously installed for the purpose of not only services, but to prevent them from being destroyed or breaking away. The utility poles in and of themselves are obstructions and hazards in the right of way.
In the right of way.
Correct.
Yes.
But in that case, there's usually some kind of governmental immunity, unless it's wanton or reckless, correct?
Well, correct. And in the Turner case, there were 2 prongs to that case that they dealt with the immunity or the immunity issues there. But the second prong of the Turner case is that there must be an obstruction that interferes with the ordinary course of travel. So it's the second prong that we're here for. And that's why the Turner case acknowledged that second prong is applicable to both public and private landowners. So number one, this court has already addressed this issue and has dealt with hazards like utility poles and has not carved out an exception. The only duty owed for such an object is if it interferes with the usual and ordinary course of the traffic. Number 2, as I discussed, the Pandora box would be open for practically every object along a highway, whether it's these parked cars for a barbecue, whether it's a vegetable stand or the utility poles or ditches. Those in and of themselves are obstructions and hazards. And this court—
Is that necessarily true, counsel? Wouldn't you have to have other facts to meet a burden of proof? Wouldn't you have to have facts like in this case where allegedly the homeowner had not only constructive but actual knowledge of why mailboxes aren't to be fortified so they don't break away? Just putting the car out to sell it wouldn't necessarily implicate liability automatically. You'd have to have other facts. Doing it in a snowstorm where there's black ice, maybe that would be a fact.
Well, and I think the key here then is that the factual determination is whether or not that object, whether it's a car, whether or not it's the mailbox or utility pole or a boulder or rock, the factual issue would be whether or not that obstruction or hazard interferes with the ordinary course of travel. And here it's undisputed that the mailbox did not interfere with the usual and ordinary course of travel. And that's why there was no duty here. So that would be the factual determination. And with regard to the restatement, 368, this court, that's from 1965 through the whole slew of cases over the 3 decades, this court has never adopted it. And most importantly, 368 does not create a duty because it only applies to those drivers, motorists, that are reasonably driving on the highway, or those foreseeable motorists that deviate from the roadway in the ordinary and usual course of travel. So 368 would not apply here also.
Thank you. Thank you, Mr. Lake. Ms. St. John, you've used your time. I'll give you a minute. You'll have to unmute.
Thank you, Your Honor. I was having a hard time with the mouse. I want to emphasize once more that we are talking about affirmative conduct, and Mr. Leake has not identified a public policy justification for permitting the landowner to consciously create this hazard where it's highly foreseeable that it would be injurious to a motorist. With respect to the point that even if you comply with the Postal Service guidelines, it still could be a hazard because, the bicyclists could hit it. Again, we're talking about what's reasonable under the circumstances. We're talking about the existence of a duty. And the Postal Service guidelines certainly inform this argument because this has been a studied consideration. Another point I want to make with respect to legislative authority, the legislature has chosen not to act, and the appellees have not cited a single Ohio case where this court has declined to recognize a duty in the absence of legislative action. So this is not a case where the legislature has acted and said what the duty is. We're back to the common law where the court determines that based under a standard of reasonableness and foreseeability. And again, foreseeability and public policy, those are the two basic criterions for determining the existence of duty. And I have yet to hear a public policy justification for the landowner in this context. A final point.
Thank you, Ms. John. St. John.
Thank you.
Thank you. Thank you, counsel. We'll take the matter under advisement and you'll be notified of our decision.
Okay, thank you, Your Honors.
The last case this morning is 2020-1513 Mahoning County Bar Association versus Joseph Raymond Massacho for the respondent, Mr. Johnson.
Chief Justice O'Connor, and may it please the court, I'd like to reserve 3 minutes for rebuttal. The respondent in this case was charged with violating Rule 8.4C of the Ohio Rules of Professional Conduct, which prohibits a lawyer from engaging in dishonesty, fraud, deceit, or misrepresentation. This is one of the most serious violations an Ohio lawyer can be charged with because it implicates his or her integrity. As we have laid out in our brief, misrepresentation means intentional misrepresentation and not the type of negligent misrepresentation that's present in this case. In every other notary case, the lawyer either notarized a signature he didn't witness or have acknowledged, or falsely notarized his own signature as someone else's, or notarized a blank document intending that it be signed outside of his presence and used. In other words, the lawyer intended to circumvent the requirements of notarization by making misrepresentations about the circumstances of execution. He or she engaged in intentional misconduct. This case is different. Respondent intended to witness his client sign the documents he prepared, and his misrepresentation was negligent, not intentional. There are 4 ways to demonstrate that a negligent misrepresentation does not violate Rule 8.4c. First, the other conduct prohibited by that rule is all intentional misconduct. The word misrepresentation must be read in context. Second, the notary statute itself, Ohio Revised Code Section 147.141, prohibited acts, prohibits, quote, affixing the notary's signature to a blank form of an affidavit or certificate of acknowledgement and delivering that form to another person with the intent that it be used as an affidavit or acknowledgement. This language is quoted at page 7 of our brief. That is not the case here. Third, other rules found in the Ohio Rules of Professional Conduct involving misrepresentation require intent. Rule 3.3a prohibits knowingly making a false statement of fact or law to a tribunal. Rule 4.1a prohibits knowingly making a false statement of material fact or law to a third person in the course of representing a client. A negligent misrepresentation of law or fact to a tribunal is not prosecuted under Rule 8.4c, and the same is true of a negligent misrepresentation to a third party. And fourth and finally, this court's prior opinion in Disciplinary Counsel versus Mecklenburg. Mecklenburg was pulled over and cited in Indiana for driving under the influence, and his driving privileges were suspended for failing to submit to a breath test during that stop. At the time, his Ohio license had expired. Mecklenburg went to the Ohio BMV to renew his expired Ohio license and signed a pre-printed form stating that his driving privileges had not been suspended and that he had no pending citations in any state. This was untrue. It was stipulated that Mecklenburg had acted on the advice of counsel and that he had failed to read the entire application before signing it. The Board of Professional Conduct found that in the light of the fact that he had sought and acted on the advice of counsel and signed a pre-printed form, quote, his conduct did not constitute an intentional act of dishonesty, fraud, deceit, or misrepresentation. This court adopted that finding and dismissed the 8.4c charge. So that decision unambiguously stands for the proposition that the misrepresentation prohibited by Rule 8.4c is an intentional misrepresentation, and intentional misrepresentation is not present here. The cases cited by the board in its 2 cases cited in the report and recommendation were the Cincinnati Bar versus Thompson and Cincinnati Bar versus Gottesman. In Thompson, the lawyer had notarized 2 affidavits for his former law partner, and the former law partner was going to try and have a business associate who he was in a dispute with sign those affidavits and thereby get his name removed from 2 Kentucky liquor licenses. So the lawyer, Mr. Thompson, notarized those blank affidavits, left the dates blank, knowing that his partner was going to go get them executed and then use them for a purpose. Obviously factually distinct from what's happened here. In Gottesman, the respondent was presented.
How, in the Mecklenburg case, can you help me, how does acting on the advice of counsel translate to unintentional misrepresentation?
I think the board found that the combination of the stipulation that he hadn't entirely read the form and that he had talked to a lawyer before he went to get his Ohio license reinstated obviated any intent to make a misrepresentation. That in the quote that is in our brief, that was the board's conclusion, that based on those 2 facts, he didn't intentionally make a misrepresentation.
Thank you.
In Gottesman, the lawyer was presented with a signed power of attorney, and the person who brought it to him said, "This is my wife's signature." Gottesman notarized it. It was used to borrow $75,000, and in fact, the signature was forged. So Gottesman knew when he notarized that affidavit that he didn't know that the signature was by the person who purported to sign it. It wasn't acknowledged in front of him. and he knowingly violated the notary statute. There are two cases cited by the relator most heavily, the Gottesman, which we've just discussed, and Columbus Bar Association versus Daugherty. Daugherty is about a liquor license as well. There, the lawyer provided his client with a blank application for 2 temporary liquor permits, which would allow the client to sell liquor for 48 hours during a special event hosted by a nonprofit. The client returned the application to the lawyer with a signature purporting to be the signature of the nonprofit's president. Respondent notarized the signature and then submitted the applications. As a result, a liquor permit was issued. The signature turned out to be forged. So here the lawyer knowingly and intentionally notarized the document he didn't see signed or acknowledged, and he submitted it. In the instant case, the respondent did not intend to have his powers of attorney signed outside his presence. He didn't tell his client to do that. He intended to return and witness them being signed.
But
And-
counsel, I understand his motive for, here's the documents, take a look at them, clients with your children, whatever. And I'll come back then and I'll answer any questions and we will execute any documents or I'll make any changes you need. That's pretty much the scenario I think that I understand. But they never contacted him after that. Neither the husband or wife, nor I believe he was dealing with the son, Robert. Is that correct?
That's
Okay,
true.
nobody got back with him. And then there was an intervening attorney-client relationship facilitated by the daughter, correct?
Correct.
All right, so he knows that he's got these documents out there and they've got his notarization on it. Why wouldn't he have pulled them back or asked them to be destroyed?
That's clearly what he should have done, and that's the negligent conduct that he engaged in. He dropped these documents off on July 28th, and they signed new documents with a different lawyer a month later. So the documents that he left there were revoked as a matter of law when the new documents were executed. And there's no evidence that that this particular document, which was the only one that was ever signed, was ever used. So
Right.
he clearly should have followed up.
All right, and your client, when testifying on this, was upfront, honest, made no deceptive responses, correct?
Absolutely. When he first became aware of this document, signed 2 years after he had dropped them off at the house, he went back to his office. He was deposed in a will contest case. It was presented to him as an exhibit. He went back to his office and self-reported that day. So there may have been other parts of the Code of Professional Conduct that this negligent conduct violated. He perhaps could have been charged with a lack of competence under 1.1 or lack of diligence under 1.3. But 8.4C questions his integrity, his honesty. It involves honesty, deceit, fraud, misrepresentation. And this is an outstanding lawyer with a spotless record who has been a prosecutor. The character letters that support him demonstrate his character. He shouldn't be saddled with this for this kind of a negligent misrepresentation. And this is a very unusual case in the constellation of notary cases. It is more akin to Mecklenburg than any of the other notary cases because everybody else intended to do something wrong. So if there are no other questions, I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Mr. Slipsky.
Chief Justice, and may it please the court, my name is Ron Slipsky, and I am here today on behalf of the Mahoning County Bar Association. As Mr. Johnson alluded, the parties are before the court on respondent's objection to the report and recommendation of the Board of Professional Conduct. The Board of Professional Conduct found by clear and convincing evidence that respondent violated 8.4C and indicated that he should receive a public reprimand for his conduct. We urge the court to find that the board made the correct conclusion in its report and recommendation. I would begin by observing, first of all, that the rules of professional conduct are not designed to punish attorneys. The rules of professional conduct, one of the major purposes of the rules of professional conduct is to protect the public. This case illustrates that purpose. This case illustrates the danger of the kind of conduct that respondent engaged in, and it creates a threat to the public. We have no ill will to respondent, but given the cases that are there and the kind of activity that occurred here, we believe that a sanction is appropriate. We agree with respondent in his brief when he talks about the fault line, that there's a fault line that runs through all of these 8.4C cases. We agree that there is a fault line, but the fault line is not in regards to whether or not the respondent engaged in a misrepresentation or not. The fault line is, having engaged in that misrepresentation, what should the sanction be? And as I hope to explain as we move forward, the issue is, should it be a public reprimand, or should there actually be a suspension of his law license?
Counsel, couldn't the outcome be that we find no violation? It doesn't have to be what's the punishment here, not punishment, but what's the sanction here. It could be that this court deems this not to be an 8.4 violation.
That's correct. And I hope to demonstrate that it is a violation, because there was a misrepresentation here, a false statement, and the potential harm to the public is illustrated by this case.
Okay,
Isn't Mr. Johnson correct that there has to be some kind of intentional that there has to, that just a negligent misrepresentation isn't enough?
Yes, no, he's wrong. All of the cases talk about.
So if I'm talking to a judge and I say, I'm an attorney, and I say that adamantly that yes, I did file this document. I find out later on that I didn't. I should have checked with my assistant and made sure there was filed, but it wasn't. So I misrepresented something to the judge. That wouldn't be a violation, would it?
No. And the difference is, we are dealing here with a notarization. When someone notarizes a document, it becomes a self-authenticating document. And in this case, that self-authenticating document, unsigned, goes out, okay? What Mr. Maseko does is he relinquishes control of that document.
But the misrepresentation, isn't it? I mean, you're talking about the potential for harm here, but the issue is whether there is an intent that has to go beyond negligence. That's to go to the misrepresentation. That really is not a. I mean, what you're getting to is that in this case, the misrepresentation could have had bad effects, but that's different than whether something's negligence or not.
Well, all of the cases talk about whether or not the respondent followed the rules of notarization, and where the only thing that the respondent did was not follow the rules in notarizing a document. That's all that he did wrong. A public reprimand issued in every single one of these cases.
But Mr. Slipsky, the false statement or the misrepresentation was actually the language, assuming he had a stamp. And so it was the language in that jurat and perhaps his signature, because I'm assuming he signed it as well.
Yes, that's the misrepresentation. That's a full stop. There's a misrepresentation there.
Now, if he had not signed it and just used his stamp, would that still be a misrepresentation?
That's a good question, Your Honor. I would have to research that. I suspect no, because the stamp would be meaningless without the signature.
Thank you.
Okay, so if I can try to get back on track here. I will skip ahead then, since we covered most of this in terms of the potential harm. So what he does is, let me skip forward to the Thompson and go to the cases. The Thompson case is the one that is most like the case at bar. Of all of the cases cited by the party, Cincinnati Bar versus Thompson. In that case, Thompson notarized 2 blank documents for a former law partner. That's all that he did. Unlike here, the documents were never signed, so here it's even more egregious. But the court pointed out in Thompson that there was no evidence of any attempt to deceive anyone. There was no dishonesty involved whatsoever. It was exactly as it is here. This violation of how you notarize a document.
But I guess this is, I guess, what I'm troubled with a little bit. I mean, I think we all can agree he violated the rules about notarizing a document, but that's not what he's charged with. He's charged with violating Rule 8.4C that says it's professional misconduct to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And I think we all agree that this can't be any misrepresentation. It has to have some kind of, scienter there beyond just negligence. So how does doing the notary thing wrong get you to conduct with dishonesty, fraud, deceit, misrepresentation?
Well, he signed a statement that said, and I quote, "This document was acknowledged before me this 28th day of July, 2017 by Mary Lou Durick." He signed that and notarized that. In our opinion, that is a misrepresentation. It's false. He did not do that. And 8.4C indicates that it is unprofessional conduct for a lawyer to engage in a misrepresentation.
So anytime a lawyer misrepresents something, they have violated that rule, whether they intended to or not.
I can't speak for all the cases that may be out there, Your Honor, but in this case where he signed this statement, this is a misrepresentation. That is.
And at the time he signed that and notarized it, he knew there was no signature on there that he represented was there, correct?
Correct. And he has subsequently admitted that that statement was false. And that is a misrepresentation in our opinion.
Left the documents, and depending on how it was situated, said, I'm not going to leave the signature page here since I've already put this on here, and I'll wait for you to look at it. And, or as the chief said, he could have just followed up and said, hey, did you sign those documents?
Correct. And that would have alleviated the problem.
Well, no, it would not have alleviated the problem, because if he called up and said, hey, did you sign those documents? And they said, oh, yeah, they're all done. Then it's still a false statement because he didn't witness her signature.
That's correct, Your Honor. And in that regard, I would refer the court to Mahoney County Bar Association versus Malnet. In that case, respondent was a member of the Army Judge Advocate General Corps. He was called up for duty when the war in Iraq broke out. He was facing a summary judgment by opposing counsel. He prepared some affidavits and he asked a trusted friend to circulate the affidavits. The friend circulated the affidavits, brought them back to him, and 3 of them were signed. He did not ask for signatures. When he returned from Iraq, he was ordered to Virginia. And in that case, then, before he would use the affidavit, he called each of the people who signed it to confirm that that was, in fact, their signature and that everything in the affidavit was true. This court nonetheless found, okay, and this goes directly to your question, Chief Justice, this court still found that there was a violation. And he received a public reprimand because the only thing that he did wrong, again, was the way he notarized the document.
But what if everything had gone exactly as the attorney planned? If he had pre-notarized these, but then an hour later the client had signed it, would there be a violation? He witnessed the signature, so he witnessed, so everything, so it was accurate an hour later, but it wasn't accurate when he first affixed his stamp and signature to it.
I believe there would still be a technical violation. Whether or not it gets prosecuted is another question, but it's still a misrepresentation. When he made it, it was false. And you know, that brings me to there's a line of, well, not a line of cases, but beginning with Fauerbaugh. In Fauerbaugh, the court expressed its concern that lawyers they were seeing more and more cases of dishonesty with lawyers, with their clients, and with the court. So the court announced a rule in Fauerbaugh, a strict rule, that anytime anyone violates 8.4c, they're going to get an actual suspension. Fast forward 10 years to the Doherty case, and the Doherty case is like this one. There was nothing done wrong in that case other than failing to follow the rules of a notary. In Doherty was a 4-3 decision, a split decision, that even there, the 3 dissenting judges still felt that the person should receive an actual suspension. The majority of 4 felt that a public reprimand was appropriate, and that case is cited in the Thompson case. As my time's running out, I would like to speak to the 2 cases in their brief that respondent rely upon most. And the first one is Mecklenburg. Of all of the cases cited, it is our position that Mecklenburg is most unlike this case. Of all of the cases, it is most unlike this case. In Mecklenburg, Mecklenburg did not notarize a blank form. In Mecklenburg, Mecklenburg did not notarize anyone else's signature. He did not acknowledge anyone else's signature. The document that he signed in Mecklenburg was not self-authenticating. In Mecklenburg, he was not acting either as a notary or as an attorney representing someone.
But he was an attorney.
He was an attorney, yes. And so in Mecklenburg, the court said, in light of the facts that Mecklenburg had sought and acted on the advice of counsel and signed a pre-printed form provided by the Bureau of Motor Vehicles, his conduct did not constitute an intentional act of dishonesty, fraud, deceit, or misrepresentation. I think the court in that case essentially negated this concept of intentionality because he was acting on the advice of counsel. If you're acting on the advice of counsel and counsel tells you it's okay to sign that form and it's not a misrepresentation, it's a little bit hard to claim that the person made a misrepresentation. However, going to, I think it was the Chief Justice that spoke up, Mecklenburg, although 8.4c was dismissed, he was found to have violated 8.4h, and that his action adversely reflected on his fitness to practice law. The other case that they rely upon in their brief is disciplinary counsel versus Friedman. In that case, an associate attorney notarized some blank signature lines on a mortgage and deed for Friedman's wife. Interestingly enough, the wife later signed an affidavit indicating that Friedman had the authority to sign her name there. Nonetheless, the court found a dishonest motive. It's interesting that respondent cites this case for the fact that the person, the associate attorney who actually did the notarization, was not prosecuted. I don't know how that stands as authority to support what respondent is arguing here. We have no indication, no explanation whatsoever as to why that particular attorney was not prosecuted. And to claim that that's authority for the proposition here that the complaint against respondent here should be dismissed just doesn't hold any water in our opinion. For the reasons in our brief and the reasons I've tried to delineate here, we urge the court to adopt the well-reasoned and supported report and recommendation of the Board of Professional Conduct, find a violation here of 8.4c, and provide a public reprimand so that the message goes out to attorneys in Ohio and also to notaries public that you under no circumstances notarize a blank document. If there are no further questions, I thank the court for your time.
Thank you, Mr. Slipsky. Mr. Johnson.
Your Honor, Mr. Slipsky's first statement was that these, obviously a true statement, that the rules are designed to protect the public, not to sanction a violating lawyer. At page 42 of the transcript, relator stated, the reason we're here is not to protect the public via Mr. Maseko, but it's against future acts by other lawyers. So the rules aren't designed to make examples. They're designed to protect the public, and the relator has admitted the public doesn't need protected for Mr. Maseko. The notary statute itself requires intent in the prohibited acts. And the question by Justice DeWine hits it right on the head. The timing doesn't matter. According to relator, if the lawyer had signed the notarization form and then slid it across the boardroom table for his client to sign, he would have violated 8.4C, because at the moment he executed the notarization, the client hadn't signed it yet. That is a ridiculous conclusion. And in Mecklenburg, it is simply untrue to say that there was no misrepresentation. Mecklenburg signed a form under penalty of perjury that had an untrue statement in it. It said that he wasn't cited in any other case and that his license hadn't been suspended in any state. Both of those statements were untrue. The board's decision and the court's decision was that there was no intent in making that misrepresentation. So the misrepresentation wasn't erased by the advice of counsel. The intent was.
Mr.
And
Johnson,
so
it seems like your colleague says, though, that the import of this document makes it different from Mecklenburg because a notarized document is self-authenticating, and that Mecklenburg's document was not of the same import.
well,
Does that matter?
it doesn't, because there isn't a special rule in the Ohio Rules of Professional Conduct dealing with notaries. We're in a basket that covers fraud, deceit, dishonesty, and misrepresentation. And so there was no harm to anyone because there's no evidence this document was ever used. And again, if we're talking about the notary statutes, the notary statute of prohibited acts prohibits signing a blank document with intent that it be used. And that's not present here.
But Counselor, but if we have found that there is no violation, doesn't this open the door for lawyers to sign or notarize documents that are unsigned?
No, Justice Stewart, I don't think it does. This is a very peculiar situation. What it says is that you are not committing a misrepresentation by making a mistake. You still,
but is it a mistake when your client knew when he notarized a document that it had not been signed?
it's a mistake when he intends to see it signed. The intention is to give a client a document or a third party a document and say, here it's notarized, just sign it and use it. You still can't do that. This case won't change that a bit. And the fact that he was only charged and found guilty of one violation doesn't mean, as I said, that this conduct doesn't fall under a different rule. But just like with criminal law, you have to be charged with the statute that you violated. If they charge you with the wrong thing, they can't find you guilty because they think you've done something wrong. And finally, I think you start a dangerous precedent by saying that any misrepresentation, no matter how innocent, violates 8.4C. As Justice DeWine pointed out, a negligent misrepresentation to a court would then be chargeable not under Rule 3.3A, but under 8.4C, which to my knowledge has never been done.
All right, counsel, this was one incident that your client was involved with, presumably.
Correct.
If this was a habit, a pattern, there was testimony that this is how he approached all of his in-home visits with potential clients or clients. What would you say to that?
That would obviously be more troubling because then you start to question his intent. Is his testimony that he didn't intend these to be signed and used truthful? Or is he making a misrepresentation to try and cover what his practice really was? Just draft the documents, sign them, drop them off, and let the clients go on their way. So
well,
I think
it's also a cumulative violation of the notary standards.
That's true.
Which is, like a cumulative violation of speeding tickets, et cetera, which is, something we would look at.
Absolutely, Chief Justice, I agree.
Okay. All right.
I'm down to seconds. I thank you all for your time.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.